That offer is off the table. That agreement is now not valid.
Judge, we can pay the $865 today. We will pay it. $865 cash on the barrelhead today. That therefore we have kept our end of the agreement. I will tender a check off my account today. Now, I want him to fulfill his part of the agreement because he hasn't.
Your Honor, I'm going to object for about the 13th time to Mr. Hill's unprofessional behavior of accusing me of not fulfilling the agreement. And he was provided what I was given, Your Honor. I'm not an accountant, I'm a lawyer.
Yep. Okay. Go!
Will you hand me my screen box? Now go freak.
Louisville versus Vinay Lawson.
Well,
Are there any preliminary motions before we begin?
Judge, I don't know if we're here specifically. It's our position that I know Mr. Ben's position is that they provided us a ledger per our agreement that we had when last we were in court on June 17th.
Mm-hmm.
It says initial payment must be paid by that date, July 8th. Plaintiff will provide a ledger to defendant. Defendant will seek assistance on a document that says rent ledger from Vinay Lawson was provided.
Okay.
I'm going to provide this to the court. Now, sure, the document that you emailed me, you emailed it to me the same day. I passed it on to my client. And I think what we're at the rub is whether that's a rent ledger. It's my position that a rent ledger was not provided. A purported ledger was provided, but I do not believe that it meets the definition of a ledger. By the time I provided my client, I had left town. I was down off of Gulf Shore, Alabama, working on a boat. So the question in my mind, the position that I have is that a rent ledger? I don't believe it meets the definition of the rent ledger because it only shows amounts due. It's really a past due statement, not a statement of what was paid, what is necessary. It doesn't show debits, it doesn't show credits, it doesn't run the length or any real length of the lease, and it's inaccurate. I have here, well, I'll wait for that. But Judge, I think that if we took any
comment, Your Honor, he didn't preserve that earlier.
If you take any standard definition of a ledger, it's going to be not just what you
Objection. We went through this earlier. He has no definition of a ledger he's ever provided.
I asked the court to take additional notice of any learned treatise, including Black's Law Dictionary, Oxford.
Objection. He didn't provide us a copy
of the definition of a ledger.
Okay, let me stop you for 1 second. Did your client make the initial payment by July 8th?
Today is July 8th, Judge.
Okay, yeah, you're right. Today is July 8th. Has she
No
made?
ledger was provided.
Well, it's a two-way street, okay? So I at least have something purporting to be a ledger. Whether it's a ledger or not, we can certainly get into, but is she prepared to make the first payment today?
And she was supposed to have had that ledger and been able to get rent assistance to make that payment.
Objection, Your Honor, that was not the deal. Mr. Hill keeps trying to change the terms of the deal. The deal was that she would make an initial payment by today at 11 a.m. We would provide a ledger, which was provided to Mr. Hill at 3:58 p.m. on June 17th. Mr. Hill never commented, responded in any way, shape, or form until 3 minutes before the 11 a.m. docket today, saying there was an issue with the ledger and rent assistance. My position is very clear. He had 3 weeks. If he didn't think this met his definition of a ledger, he should have brought that up in those 3 weeks so that we could have submitted a document to his satisfaction. This agreement had 3 parts. Part 1 was Ms. Hill was to make a payment. She failed to do that. Therefore, she's breached the agreement. We, in a good faith effort, provided our part, which was part 2, providing a ledger. Then Ms. Hill was to seek rent assistance. We don't know if there was any rent assistance sought or not. We have no evidence of that. We'll assume there is, since Mr. Hill says there's issues with rent assistance in the ledger, but she still breached part 1 of the agreement and we fulfilled our obligations.
Okay,
Judge, I'm going to read a document, which is an email from Mr. Benz. Mr. Benz, this is an email dated Monday, June 17th, 2024, 4 p.m.
3:58 p.m. if we want the accurate timestamp.
4 p.m. on mine, but
It's 3:58 on mine. I have it on my screen.
guys, please.
it says, she is only paying $865 by July 8th, and the rest will come via assistance. I do not think that would cover the amounts owed unless rent assistance. It's never anticipated that she was going to pay $865 day up. It was anticipated all along that we would receive a ledger that would be acceptable, that would reflect a deposit made and the payments made or not made, debits and credits against the account over a period of time. The standard definition of a ledger isn't, this is what you owe. That's a demand.
I understand, but that is not, I wrote up the agreement. I wrote it in my own handwriting. I'm looking at it right now. And it was very clear that she would make the rent payment by today. And then she would also separately seek rental assistance. But we all know that rental assistance was not going to, if she got it, was not going to be ready for today.
I believe it would have been, Judge. That's why we chose the date that we chose, which is pretty far off, 17th.
Okay, so we can argue whether or not this is a ledger. My question is she prepared or is she prepared to make a full rent payment today?
She can pay it tomorrow. She can pay the full month payment, I guess the $865 tomorrow. If that's not adequate. But at the same time, we don't have a ledger that we would have received, according to her, my client testified that she would have received rental assistance in full, covering all past due.
Then why are we just hearing about this objection to this being, whether this is a ledger or not? If you got this on June 17th.
I got under 17. I didn't measure what they're to provide me a ledger. That's not a ledger. I didn't read it. They passed it on to my client. It purported to be a ledger. I don't deal with rental assistance very often. She takes it and she finds out it's not a ledger. It's just a statement of past due amounts. It's not a statement of payments made, not to mention it's inaccurate.
I agree. I mean, at a certain point, had Mr. Benz been made aware of that on June 18th or 19th or 20th, he could have provided you with a new ledger. But I don't know. Mr. Benz, is your client willing to wait for tomorrow for full payment? And you can get an actual ledger. We can continue this as amended.
I made them an offer earlier that they didn't even respond to, Your Honor, that
in a week.
I would give them standard agreement for payment in full or to vacate for next week since they breached the terms of this agreement.
I submit they breached the terms of their agreement as well.
I think. Okay, Mr. Benz.
I think Mr. Hill.
Can I ask a question, please, Mr. Benz? The question I asked you was, are you willing to roll this till tomorrow at 11 for both sides to completely adhere to the original terms, which is that Miss Lawson will make one full rent payment before 11 a.m. tomorrow morning, and you will help your client with a full ledger, which includes payments made, payments owing, in and out, what you and I typically see as a ledger in this court.
Paul, are you all willing to continue this any further with this tenant?
No, sir.
Okay. Then I think the other, Mr. Hill, the other option is the 1 week standard agreement that they offered you.
Well, once we reach standard agreement, still have them providing me a tenant ledger. It's just, this agreement has failed. And what it has done is it's disrupted my ability to have a hearing because we have genuine issues of fact that should be tried. I prefer a trial.
Well, you didn't ask for a trial until today. And this requires a trial. If you want a jury trial, you have to ask for it on first call. So, I'm sorry, Mr. Hill, but this
What are
is
we
at
looking at as
least,
the standard offer?
huh?
What are we looking at as a standard offer?
Mr. Benz, do you want to, put that in words, your standard offer?
That the tenant would have her account paid in full or vacate and return possession by 11 a.m. next Monday that would be July 15th, 2024.
Will they provide a tenant ledger?
If it is going to mean we would receive payment in full, I can certainly try to get a ledger from them. I believe the document you already have shows the amounts due and owing.
Would you object to we negotiated agreement, which at your reading, we both may have come up short. But without the tenant ledger, we weren't able to get the amount that would have been due from rental assistance. It is our agreement I was prepared to go to trial. Both Mr. Benz and I were prepared to go to trial. We were set for a hearing on that day for a trial.
Why are we talking about what happened in the past? Does she want the standard agreement or not?
I want a trial.
Here's the problem. You then entered into an agreement. Your time for your trial was passed. You, instead of going to trial on that day, you asked to enter into that agreement. You came to an agreement that it would be passed today on those three terms, okay? I agree, probably both of you came up short, but the fact of the matter is that offer is off the table. That agreement is now not valid.
Judge, we can pay the $865 today. We will pay it. $865 cash on the barrelhead today. That therefore we have kept our end of the agreement. I will tender a check off my account today. Now, I want him to fulfill his part of the agreement because he hasn't.
Your Honor, I'm going to object for about the 13th time to Mr. Hill's unprofessional behavior of accusing me of not fulfilling the agreement.
I mean, I think Mr. Hill, at some point, if he gave this to you and you didn't read it, I have to agree that's not all on him.
It
okay?
wasn't my duty to extract a ledger from him. It was his duty to provide a ledger to me.
All righty.
And he was provided what I was given, Your Honor. I'm not an accountant, I'm a lawyer.
So, I guess we'll just take testimony on the eviction. Mr. Benz, who should I swear in?
That would be Paul, what's Paul's name? Johnson, I think.
I'll take standard.
Yeah, I'm sorry, Jones, Paul Jones.
Judge, I'll take standard.
Standard agreement? Okay, so that would be next Monday.
I want the court to note my objection that if we were prepared for a trial, we had a settlement, we fell short. I object to not being able to have a trial.
Okay. That is 8:15 at 11 a.m. on
7:15, Your Honor. It's not August yet.
7:15, sorry. 7:15, thank you, Mr. Benz, at 11 on standard agreement. Thank you.
Thank you all.
Louisville Metro Housing Authority versus Carol Turner. Oh, was this a review? This was on for today for a review?
It was
No.
on for a hearing, Your Honor.
Okay. Who should I swear in, Miss Avery?
Wendy Osborne, and I believe I have another gentleman on the line, Rashid. What's his last name, Wendy?
Harrison.
Harrison.
Okay, which one would you like to go first?
Wendy Osborne.
Okay, Ms. Osborne, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be nothing but the truth?
Yes.
Okay, go right ahead.
Miss Osborne, where are you currently employed?
Louisville Metro Housing Authority.
And
Sure.
what is your, I'm sorry, go ahead. Go ahead.
No, I said Shepherd Square.
And what is your job title?
Property manager.
And are you familiar with Carol Turner?
Yes.
And how are you familiar with Miss Turner?
She's a resident here.
And is her address 75?
That's correct.
And is that part of the Shepherd Square property that you're the property manager for?
Yes.
Did you have reason or occasion to send notice to Miss Turner on or about April 9th, 2024?
Yes.
And the reason for your sending of the notice?
To do a housekeeping inspection.
Okay. And when you performed that inspection, was Miss Turner present?
Yes, she was.
Who else was present in that unit?
Her son.
Okay. And was there anyone besides yourself on behalf of that housing authority?
Rashid Harrison was with me.
And during the inspection of the property, what happened?
We went in, she was telling us that her dishwasher hadn't worked since she lived there. So Rashid went to look at the dishwasher. He looked at that. I proceeded to do the inspection of her apartment. So Rashid had came, to stand with me, and I asked her to open up a door that was closed. And she opened the door, and there was a dog in there, and her son was in the bathroom, and
Let me stop you right there. So there's a dog. Is there a dog? Is Miss Turner supposed to have a dog pursuant to the lease?
No.
Okay, go ahead. Keep on.
So then her son exited out of the bathroom and went into the living room. And that's when Miss Turner pushed me out of the way. Yeah.
Why did she push you? Like what? Like pushed you out of the way to go where?
I was actually shocked. She just literally shoved me out of the way.
Okay. And did this inspection occur at some point during March of 2024, or did it occur in April?
March.
Okay. And then after Miss Turner pushed or shoved you, what did you do?
We pretty much summed up the inspection at that point and decided to just go ahead and leave.
Okay. And after you finished the inspection and left, did you report this incident to anyone else?
No, me and Rashid, and I sent an email to my supervisor. Yeah.
Okay. And based on that incident, is that what caused you to file the eviction today?
Yes.
And is it your stance that the shoving by Miss Turner of you is a violation of her lease?
It is.
And why do you think it's a violation of the lease?
Just because she put her hands on me, and I know that if it had been vice versa, it would have definitely been, I would have been at fault too. But yes, it's definitely a violation.
That's all the questions I have for Miss Osborne, Your Honor.
Okay. Ms. Turner, do you have any questions for Ms. Osborne?
Yes, ma'am.
Okay, you're gonna have to speak up.
Okay. I did not.
No.
What?
Now
What she's saying.
is only time for questions. I'm gonna get to your testimony, okay, but right now it's only if you have any questions for her. If you don't have any questions, that's fine.
I don't know what she's up there lying. I did not.
Do you have any questions for her, ma'am?
No.
Okay. All right. Mr. Harrison, would you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be nothing but the truth?
Yes.
Okay, go right ahead.
Mr. Harrison, who are you employed by?
Louisville Metro Housing.
And what do you do for Louisville Metro Housing?
I'm the maintenance supervisor.
And were you in there in March when the alleged incident occurred?
I was.
Why were you present?
We had a work order for her dishwasher. She said it wasn't getting power, it wasn't working. So we were there to look at that.
Okay. And did you indeed look at that unit while you were there?
I did look at the dishwasher.
Okay. And did you at any point see Miss Turner push or shove Miss Wendy Osborne?
Yes, she did. We were all in the hallway at the time, and we had just talked about the bathroom and, something going on in the bathroom. And I asked, could I look at the bathroom to see what she was talking about? And at that time, right before that is when her son had left the bathroom. And that's when she was the furthest person in the hallway. So she was trying to get past Wendy and myself to get into the bathroom. I didn't know if maybe she was trying to close the door so that we couldn't see what her son was doing or what, but that was why she tried to get past, was because he had came out and we were trying to go in there. And that's when she shoved Wendy.
Okay. And was it indeed a shove, or was she just trying to get past her, maybe bumped her, or do you think it truly was a shove?
Oh, it was multiple steps, because at first it was trying to get past, and then it was a full shove, because afterwards Wendy looked at me and said, you just shoved, looked at me and she said, you just shoved me. And she said, yes, I just shoved you. I was trying to get past you, wouldn't get out of the way.
Okay. All right. And after that happened, did you all remain in the apartment, or what did you do?
After a few seconds of just kind of being shocked, and like Wendy said, we were just kind of shocked at what just happened. We kind of shut it down and said, okay, well, we'll reach out to you at a later time.
No, that's all the questions I have for Mr. Harrison.
Okay, ma'am, do you have any questions for him? No? Okay. Do you have any further witnesses, Miss Avery?
No, that's all the witnesses I have, Your Honor.
Okay. Ma'am, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be nothing but the truth?
Yes, sir.
Okay. Please go ahead. You can tell me whatever you'd like. Just keep your voice elevated, okay?
My grandfather was hard of hearing and talk loud. Okay. That is not true. My son was not.
Can you hear her?
Yes.
Okay.
Okay, that is not true. My son did not go to the bathroom. The bathroom door was open. He was at the kitchen entrance and the living room. I was in my hallway. He was facing the fuse box with the fuse box open, and my son said, "Are you here to do with the repairs?" No need to check the fuse box. The dishwasher has been unplugged since '99. I've had no dishwasher. It's unplugged, you see, and they never removed it. Okay, so that's okay. My dog, I just got as a service dog because somebody tried to break in. He is licensed as a service dog. I was told I could have a service dog because of my health and people. Now, he was looking at the fuse box, and I came up, and I'm gonna get up, I'm not gonna bother nobody. And she was standing in front of me, and I said, "Excuse me, can I go to the bathroom?" Okay, she didn't do nothing. I said, then, "Excuse me," just raised my voice. "I have got to go to the bathroom. I do not want to pee on myself or vomit because I had a stomach bug." So she would not move. I did not push her. He did not turn around and face nothing. I am not lying. They've had it out for me for I don't know how long, and I'm on the residential board, and I hate a Fibber McGee. They have not did no repairs to me. I've got water from the upstairs apartment. I've got my thing for this is what she's mad about. They don't want to do repairs to my apartment. I have put this in since March the 28th of 23. Then they told me that somebody new took the property over. So I went back, I turned this back in. I have not got none of this done. The apartment upstairs, the fire department will tell you, the water, those little things right there, busted in Music Man's apartment. It came through the whole side, 302, 202, 102. We have got water in our wall, messed up the carpet and everything. I'll let anybody come in and see it. King, my Kia is not a bad dog. They have not came to fix the lock that somebody tried to
Yeah,
take.
she just said a name I didn't understand. Who was not a bad what? She said something I didn't understand.
Oh, the dog.
My dog would not hurt nobody unless they raise their voice or act like they're gonna touch me, and I'm sorry. There's pet bull, service dogs and everybody in that apartment complex. Go and see Shepherd Square. They do not fix the broken apartments, the shot up apartments. We just had a young boy killed in our apartment complex. Nothing is done. I am not lying. I'm on the residential board. I am the one that you can ask maintenance. I clean and you can ask her. You can ask the dump people. I'm the one that cleans the dumpster area. I tie up the garbage bags. I put them out away from the front. I try to push it over. Everybody likes me there.
Here's what I know at this point. When it gets to this point between management and a tenant, it's probably not fixable. Okay?
Well,
So-
I've had no problem with the previous attendants. I paid on time. It's these people that took over.
Okay. Well, let's see if we can't reach an agreement do you have another place you can go?
No, ma'am, I
Ma'am,
have
you're
no.
not sworn in.
No,
You
I know.
can't
I
just-
was asking you, could I say something? I know I'm not.
You're not a
sworn
party to this case. I don't know who you are.
It's my
So
daughter-in-law
I'm the mother of her grandkids.
that I raised.
you're not a party to this case. So unless you're called to testify, sorry.
Oh.
That's the way.
No,
it
I
works.
have no place to go. And this all started when my sister, our home was set on fire, and I ended up at 936 East Jefferson getting guardianship of my sister that's 76 with no right foot, the left foot. They would not move me to a first floor apartment with more rent. I even took my sister's social security checks. They could put me in another 2-bedroom apartment two income, she would not do it because my sister could legally not go up 18 steps to my apartment.
What I don't want to do is put an eviction on your record, okay?
Mhm.
And that's what's gonna happen if we can't reach an agreement today, okay? So, Miss Avery, are your clients willing to give some time for her to move out so we can not put an eviction on her record?
Ms. Osborne, would you all give her additional time to vacate?
Sure.
How long are you willing to give her, Miss Osborne? I can put it on for a review date, and if she's out, we can dismiss, and if she's not, you all, Miss Avery can file for a setup that day,
We can say the end of the month.
the end of the month.
Oh.
That's very generous. So they're willing to, usually people get 1 week in this court, but they're willing to give you till the end of the month, which is more than, I can put this on July 31st.
Can I
Honestly, August 5th would be better. I'm on vacation July 31st Wednesday,
Well,
so
even
August 5th would be the closer day.
I'll take that. But can I say, I'm not guilty of pushing
Okay.
her.
Okay, so we can go to August 6th at 11, if that works for, sorry, August 5th? Is that right? I misspoke, I think. You said 5th.
August 5th is when it would work better than.
August 5th at 11.
So she gets no rent from this, from then on, or what?
I'm sorry?
Oh, never mind. Oh, I don't have to pay rent.
No, you just have to be out and have returned the keys to them by that day. And if you have, I will dismiss this against you and you will not have an eviction on your record.
Okay.
Okay? Thank you. Have a good day. Okay, and Louisville Metro Housing versus Mandy Birch. Ms. Cotton, do you represent Ms. Birch?
I do, Judge.
Okay,
And Miss Birch is on the Zoom,
okay.
patiently waiting.
I see her. Hi there, ma'am.
And Judge, I do have a pretrial motion. And that is based upon waiver, Judge.
Okay,
There were two specific exhibits that were related to the waiver motion. That's Exhibit 1, a June 11th letter
okay.
from Louisville Metro Housing.
I have that one.
And then the other one is the money order receipt for June rent, Exhibit 8. I don't know if Miss Avery has any objection to those two exhibits.
Okay, so I'm sorry, the June 11th letter I have, and then what's the other one?
Exhibit 8 is a money order payment dated June 3rd of 24. It's Exhibit 8.
8, okay, let me look for that one.
And if Miss Avery doesn't have an objection, my motion to dismiss rests on those two documents being admitted.
I don't necessarily have an objection, I have a response, obviously, to our motion to dismiss, but I mean, the
So,
letter.
Ms.
Okay.
Cotton, I see a money order for $500. Is that what we're talking about?
Yes, and right before the 500, Judge, you can see the date, June 3rd of 24.
Yes, I actually have two, and one is for April and one is for June. So yes,
Yes.
June 3rd of 2024. I
So-
got it.
So Judge, this case was filed on April the 30th of 2024. And as is well known in this court, acceptance of rent post-filing is waiver under the statute KRS 383-675. Ms. Burton presented this waiver and it has also confirmed that it was cashed. In addition, Judge, the Louisville Metro Housing Authority sent the June 11th past due rent reminder. And in that, Judge, it states specifically, you must pay rent. This is your notice that your rent is late and past due. You must pay rent and a $15 late fee within 14 days from the 8th of the month. If you fail to make this payment within 14 days from the 8th of the month, your lease will terminate and an eviction action will be filed against you in state court. This letter was sent to Ms. Birch following the filing of the complaint that we're here today on, and it extends an acceptance of a performance that is different from and varies from the rental agreement and gives her an additional 14 days after the filing and indicates that the lease hasn't terminated, all in that first paragraph. And I believe that that would also fall under, if you continue reading, be advised of the following. It goes into that she must pay within the 14 days or the lease will be terminated. Rent will not be accepted unless you pay the full amount. Attorney's fees, filing the proper notice, you're entitled to a grievance hearing, which is yet another alternative issue. You may make a reply. You may be eligible for a repayment agreement. This letter is stock full of alternative performances, which could be done by Ms. Birch under 383-675, the second portion of that statute. In addition, I believe that this particular letter potentially falls under the Rich v. Rose case. Poor Mr. Zay, he's still here. He had to argue this all last week. And Miss Avery's benefit and the courts, and to make the record, Judge, the specific rule we're referencing is if the landlord accepts or undertakes to collect rent not due when notice to vacate is given, and that does not accrue between the date of the notice and the issual of the writ or rent that becomes due after the forcible detainer proceedings have been instituted, June would have been after the April 30th institution. He will waive his right to forfeit the lease under that notice. The notice referenced here on this complaint is November 6th of 2023. Which is significantly long before the April 30th notice, and the reason why I have so many other exhibits, Judge, if I were to argue this case in full and the court not grant my motion to dismiss.
Okay. There are a couple things that, I hear Ms. Cotton's argument, but I think all of it's flawed. And the first part would be the separation of the eviction versus the reason she's being evicted. She's not being evicted for non-payment of rent, although she owes greater than $6,000 in rent. Ms. Birch is being evicted for a lease violation of regarding the housekeeping standards. The non-payment of rent issue is still an issue. She's not paid rent in more than a year. And only $6,000 is owed.
To discussions regarding what she owes, as that's not the basis of this eviction.
You tendered that as your exhibit. You literally put this before the court. Your exhibit that you tendered to this court and asked that I object to, which I didn't object to, lists that the rent that is owed by Ms. Birch is more than $6,000. I mean, that's your exhibit I'm reading from. This is not something I'm making up. It's your exhibit.
My objection is specific to the court being informed concerning that violation, as that isn't the issue we're here on. And my motion is based on the behavior of the landlord and the waiver statute.
The thing of it is, you don't get to open the door and then try to shut it when it's time to be addressed of the exhibit you tendered before this court. You brought the issue up.
The objection is overruled. I think you did bring it before the court. And I understand that. I think in order to make your waiver argument, you had to do it, okay? But I don't care how much. I don't care if she owes $0 or $6,000. It doesn't make any difference to me as far as your waiver argument. Go ahead, Ms. Avery.
Okay, so the eviction, as I say, is a non-financial breach. It's not an issue of money. Even and part of Ms. Cotton's argument was that she paid June rent, therefore they can't move forward with their eviction. She didn't pay June rent. If anything, that was rent that was probably due and owing for months ago. I mean, this is like I said, from her notice alone, she owes far more than $500. I believe when it's a non-financial breach, acceptance of rent is not a waiver issue. Acceptance of rent is a waiver if you're discussing a financial issue. We are discussing a housekeeping issue that she's been put on notice ad nauseum, and they've attempted to work with her for months in order to rectify prior to filing this eviction. The only thing that they did was provide her additional time to try to get it right, and she still has not gotten it right. Therefore, they're moving forward with their eviction due to the lease violation of having conditions that are in violation of the ACOP as well as the lease. It's not a financial issue.
Okay. So,
response, Judge. The waiver statute, Judge, is not specific to financial breaches. It states very clearly acceptance of rent with knowledge of a default. this court routinely dismisses lease violation cases based on the fact that the landlords have accepted payment post-filing.
Okay, so Miss Avery, let me just ask you point blank, and if you need to ask your clients, that's fine.
Sure.
Since the notice on this case was filed, which I agree was not for non-payments, but the notice for violations of lease, which was which the notice, it says here and on your complaint, was given to the defendant on November 6th of 2023, has rent been accepted?
Yes.
Okay. I don't know how to read 383-675 other than the plain language that says acceptance of rent with knowledge of a default by the tenant or acceptance of performance by him that varies from the terms of the rental agreement. That doesn't apply here. Constitutes waiver of the landlord's rights to terminate the rental agreement for that breach unless otherwise agreed after the breach has occurred. So, I think that, and this happens a lot, and you are certainly not the first plaintiff's attorney that has argued to me that it doesn't matter if it's not for failure to pay rent. But I don't think that's what 383-675 says. I think 383-675 says, if you're going to evict a tenant for any reason and you accept rent from them, then you cannot evict them for that reason. I am perfectly willing to admit that I may be reading that wrong. And if you want to take me up on it and somebody smarter than I am wants to tell me I'm reading it wrong, I'm happy to hear that. But when I read it, that's how I read it. So I don't think that they can both file for any reason and accept rent without me dismissing. That's where I am.
And Your Honor, we respect your decision. And I don't think there's anyone more smart than you that I could take this up with.
Please.
But I would, well,
I mean, this is something that comes up on a regular, but I would say it used to come up more often until I started ruling this way. And now it doesn't come off that much, but I would love it if somebody from a higher court ruled on this and says, oh, if it's for violation of lease, you can still accept rent. I would love to know a bright line rule on this. But
quite frankly, I think I recalled, I think there may be one, but in this instance, I think the easier thing for us to do is to refile and to send new notice. Okay. And I think we'll have the same issue. We'll be here probably in the next 2 months with the same issue again. If you
find one, I will tell you that even Mr. Benz, who is the most, what's the word I should use? Well, you can imagine a word in your head and use whatever word you want. Even he doesn't fight me on this anymore. And trust me, I think if there were a case out there that he could find, he would have found it. And I've looked before and haven't found one. But if you find one, I would love to see it. Really, I mean that. This is why I love the law, because I don't mind saying I was wrong. And if you can prove me wrong, I would love to know. So please do.
I don't know if it benefits me to do that right now. In my previous life, I did the tenant work on this, and I don't know if I want to pull all my cards out, because I might need this very argument later on a different case. So I'll just
Can I pull my shovel out and also say that no one has argued waiver better in this courtroom than you did last week, Miss Avery?
Are you kidding me?
Oh my God!
You have got to be kidding me! What is going on today? This is just today is absolutely just. You need an interpreter.
I need an interpreter when I cannot express myself something.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in for people going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
I have no patience for that. But trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.